Welcome back. This is Patrick the attorney, and today I'm going to try and explain the case of District of Columbia versus Heller. This was a 2008 landmark case, and it has some very interesting facts in the case. Provisions of the District of Columbia Legal Code made it illegal to carry an unregistered firearm and prohibited the registration of a handgun, even though the chief of police could issue a 1-year license for the handgun. The code also contained provisions that required owners of lawfully registered firearms in their house to keep them unloaded and disassembled or bound by a trigger lock or other similar device unless the firearms were being located in a place of business or being used for the legal recreational activity. That means in your house you had to keep your gun unloaded and disassembled or have a trigger lock. What happened in that case? Dick Anthony Heller was a DC special police officer who was authorized to carry a handgun while on duty. He applied for a 1-year license for a handgun he wished to keep at home. Imagine that, a cop can't keep a gun at home. But his application was denied. Heller sued the District of Columbia. He sought an injunction against the enforcement of the relevant parts of the code and argued that the violation of his Second Amendment right to keep a functional firearm in his home without a license. The district court dismissed the complaint. The U.S. Court of Appeals for the District of Columbia Circuit reversed and held that the Second Amendment protected the right to keep a firearm in the home for the purpose of self-defense, and the District of Columbia requirements that firearms be kept in the home be non-functional violated that right. Question: do the provisions of the District of Columbia Code that restricted the licensing of handguns and require licensed firearms kept in the home be kept non-functional violated the Second Amendment? The ban on registering handguns and the requirements to keep guns in the home disassembled or non-functional with a trigger lock violated the Second Amendment. Justice Anthony Scalia delivered the opinion for the 5-4 majority. Remember, Justice Scalia has now passed away. He was a Second Amendment advocate for us. The court went on to hold that the first clause of the Second Amendment that references, quote, a militia is a prefatory clause that does not limit the operative clause of the amendment. Additionally, the term militia should not be confined to those serving in the military, because at the time the term was referred to all able-bodied men who were capable of being called to such service. To read the amendment as limiting the right to bear arms only to those in a governed military force would be to create exactly the type of state-sponsored force against which the amendment was meant to protect. Because the text of the amendment should be read in the manner that gives the greatest effect to the plain meaning, it would have had to, at the time it was written, the operative clause should be read to guarantee an individual's right to possess and carry weapons in case of confrontation. This reading is also in line with legal writings of the time and subsequent scholarship. Therefore, banning handguns, an entire class of arms that is commonly used for protection purposes, and prohibiting firearms from being kept functional in the home, the area traditionally in need of protection, violated the Second Amendment. In his dissent, that means the justice who disagreed, Justice John Paul Stevens, now he was against your Second Amendment rights, wrote that the Second Amendment does not create an unlimited right to possess guns for self-defense. Instead, the most natural reading of the amendment is that it protects the right to keep and bear arms for certain military purposes, but does not curtail the legislative power to regulate non-military use and ownership of weapons. What Justice Stevens was saying is that the Second Amendment did not work for the people, it worked for the government. And in a subsequent video, we'll discuss the Constitution and how the Constitution in its first two paragraphs really support the Second Amendment. A lot of people miss this in their discussions. Justice Stevens, again an anti-gunner, argued that the amendment states its purpose specifically in relationships to state militias and does not address the right to use firearms in self-defense, which is particularly striking in light of the similar state provisions from the same time that do so. Justice Stevens also noted that, quote, the people does not enlarge the protected group beyond the context of the service of a state-regulated militia. Again, Justice Stevens is saying that the Second Amendment only applies to people in the government or in military service.